webinar for the month of February. We really appreciate you coming by and listening to us and checking us out. All right. Past performance is indicative of future performance. Um, these are not tax or legal advice, just general information. Please consult your tax and legal advice and read the full disclosure on our website if you want some more information. Okay, the next thing is what are we going to cover? Number one, what is estate planning? What are some of the tools to use in estate planning? The estate tax fundamentals, estate planning strategies, and gift tax fundamentals. So let's start with a couple of key terms that we don't really um, that we have right now. Number one, what is a will? Um, Intestacy, beneficiary designation, and trust. So, number one, will. Purpose is to make sure that your assets uh, and your dependents are adhered to upon your death. Number one, it appoints a guardian of minor children. Number two, appoints executor to manage your estates. Number three, accomplishes estate planning goals with proper tax distribution. Hopefully, if your goal is to minimize taxes, must be a legal formalities as established by your state and residence. It is a public document. So, what does it mean to die intestate? Dying without a legal will, your state of residence has a will for you, right? The state intestacy statute determines the distribution of assets. And the example would be here, your husband passes away. Statistically, men are more likely to die, so that's why we're using this example. Half the assets pass to the wife, a quarter of the assets pass to the child, and a quarter of the assets pass to the second child, right? So if this is not how you hope to pass your assets, then you need to probably get a will because this is what basically the state versions of a will is for you, or in whatever state you're in. So the problem with dying intestate is simple, right? Potential for dispute among family members. We've had clients where the children were not willing to sign over the assets to mom and dad. If something happened to one of them, multiple marriages and blended families. This is probably very common nowadays, and also a big challenge, right? What if you're legally separated but not divorced? It may result in unfair distribution of the assets. You may end up leaving some of your assets to your current husband's previous children. And while you may love them and respect them, you probably don't want to leave some of those assets to them. If you have minor children, the guardian will be appointed by the court. They will appoint the person that you have. Will they appoint the person that you have selected? Maybe not. Um, I was working with a couple recently, and they said, "Well, we don't have any family that would like to watch the children." Well, the more than likely, the court may appoint a family member, right, instead of someone from your, church organization or something like that. Um, Children entitled to a share of the under the intestacy will receive it outright upon reaching the age of majority, usually 18. And is this what you have wanted, right? So, would you like to leave whatever money you've accumulated in your retirement accounts, your life insurance proceeds, going directly to the heir at the age of 18? Okay, let's talk about beneficiary designations. If you gather nothing from this conversation, the most important thing for you to know is beneficiary designation supersedes everything. I'll say that one more time. Beneficiary designations supersedes everything. Um, so, number one, your annuities, your retirement accounts, your life insurance policies, your qualified plans, right? The transfer passes outside of probate by contract and is controlled by the beneficiary designation, not the will. When's the last time you viewed your beneficiary designation? Is your ex spouse still on there? Was it when you started working at your current company 25 years ago? Maybe your sister is still on there, right? Whatever the situation is, that you have the current beneficiary designation, you want to make sure that it's up to date. Because no matter what type of document you have in hand, whether you have a will or you have anything else, um, the companies will honor the beneficiary designation they have on their records. Did you change and update your designations upon a divorce, right? So if something were to happen to you and you left your money to an ex-husband or ex-wife, how would you feel about that? Maybe you love them, maybe they're still good people, maybe you don't like them, or maybe you don't want them to have a part of your assets, or maybe just that your ex-spouse would get the assets and your current spouse, who is your current grieving widow or widower, would probably not be happy with the fact that you left some of those assets to them. So, all important things to consider when you think about your estate plan. A revocable trust. A revocable trust is, as it means in the name, it can be revoked, meaning it can be changed. It avoids probate, but assets are included in the estate of the deceased grantor. And for English terms, the word grantor is the person who passed away and put money inside the trust or is giving money into the trust, right? Um, ensures privacy, it's not public like a will. The trustee provides asset management during incapacity or after death. It avoids delays. It avoids will contests. It may be drafted as a primary asset tool for distribution with a pour over will. So a lot of people like to kind of think about a pour over will and a revocable trust and really understand, okay, here's some things I may want to do, but I can change it later, right? And that's a good thing about a revocable trust. So let's talk about revocable trust a little bit more. Number one, irrevocable trust. Irrevocable trust is, in its name again, irrevocable. Cannot be modified, can't be amended, can't be changed, can't be revoked. It manages assets for minor children. It protects assets from unreliable beneficiaries and creditor concerns, provides for multiple beneficiaries, and provides for professional management of the assets. It also does ensure that the client's estate plan is complete, right? But it is irrevocable. So once you give it away, it cannot be taken back. There's nothing you can do once you've given it away to the trust. Taxable benefits of the irrevocable trust. Assets are excluded from your client's gross estate. The trust can be granted as the trust can be drafted as a grantor trust. The grantor is treated as the owner of the trust assets for income tax purposes. Um, it allows for greater planning opportunities, right? So a lot of different ways for you to do this. A grantor is taxed on the income, in effect, a tax-free gift to the trust. Um, beneficiaries of the trust assets produce income, right? And assets inside the trust continue to appreciate outside of the estate. So, irrevocable trust disadvantages. Loss of control of the assets. That's probably the most important. Number two, cost of creating and administration of the trust. It is, again, irrevocable. And last but not least, limited ability of the grantor to retain any interest, right? So again, once you give it away, it's no longer yours. So let's talk about the five different tax regimes. Number one, there's income tax, there's estate tax, there's gift tax, there's generation skipping transfer tax, and there's state taxes if you live in one of those states that has state taxes. I'm in the great state of Texas, so we currently don't have a state tax. Not that Texas is the greatest state, but in my opinion, it is, right? So let's talk about the federal estate tax. Tax on your right to transfer property. Federal estate tax exemption is estimated to be 12.92 million in 2023, indexed for inflation. Most assets receive what's called a step up in basis in the fair market value of the assets upon death, right? Alternative valuation date may be available. The Form 706 federal estate tax return is typically required to be filed by the executor. And if any taxes are due, must be paid within cash within 9 months of the date of death, right? Let's talk about state death taxes. State may impose one or more of the following: an estate tax or an inheritance tax. The state may be decoupled from the federal exemption amount and may have a lower threshold for estate taxes. An inheritance tax is paid on by the beneficiary in the tax exemption, and the rates may be varying depending on who receives the property. So it's very important to check with your local state attorney in terms of your state taxes for your state based situation. The estate tax fundamentals. So let's talk about the important concepts. The federal estate tax and tax table and the unified credit. Let's talk about the gross estate. Let's talk about marital deductions. Now, as we're going through this process, here is the federal estate tax bracket right now. This is from the IRS, right? So that's very important for you to kind of see that. Now, let's talk about the unlimited marital deduction, right? So, transferring money from one spouse to the other is free of a transfer tax. The federal estate tax is postponed until the second death. Transfers can be outright or in trust. With the property drafting, with proper drafting, you can put it in trust with your spouse and have it pass to your other beneficiaries, but it will be included in your spouse's estate, right? So the requirements: surviving spouse must be a U.S. citizen. If they're not a U.S. citizen, it does add some different challenges, different tax rules, and that's a very detailed and complex conversation you want to have with an estate planning attorney. Property must be included in the decedent's gross estates. So, the estate tax strategy: number one, as a simple will, and I love a will. Name the executors, describe who gets what. If the decedent is survived by the spouse, the entire estate is to the surviving spouse. It's an unlimited marital deduction. That's a basic, simple, straightforward will. The estate tax strategy may be a marital trust, a bypass trust, or credit social trust. So, upon the death, the estate tax exemption of 12.92 is transferred to a trust outright, and the other to a surviving spouse. Generally, in a trust, a family trust, a bypass trust, a credit shelter trust, you know, but could be outright to the children if they wanted to. Protects the applicable exclusion amounts for the first spouses to die, can provide income for the surviving spouse, remainder to the children, right? And then it removes assets and the growth from the surviving spouse's estate. The remaining balance of the estate plan can pass outright to the spouse, right? Using unlimited marital reduction. So those are all key and really important things for you to kind of consider. So, what is portability, right? Any unused estate tax exemption at the death of the first spouse is available to the second spouse if elected. Surviving spouse may use during the lifetime to make gifts or at death. Must be elected by the executor. Estate tax returns must be filed, documenting the available exemption amount, and it's no longer crucial that the assets equal to exemption amount owned separately by each spouse now. So portability versus credit shelter trust. The primary benefit of credit shelter trust is to remove appreciation out of the surviving spouse estate. For example, assume the credit shelter trust is funded with 12.92 million, gross 18 million prior to death. The trust's value is no longer includable in the surviving spouse's estate. However, if the entire value had been left outright to the spouse, right, the 18.8 million would have been included, right? So funding the credit shelter trust, you know, may be a better option, right? Instead of using the portability option. So let's talk about gift tax and gift tax fundamentals, right? So why gift during your lifetime? Um, what are the gifting strategies and potentially life insurance in using the gifting strategies? So, why make gifts during your lifetime? Number one, minimize the tax exposure by reducing or freezing your estate value um, and growth and gifted over time. Transfer income tax liability to the donee and provide lifetime benefit to the donee. Right. So that's one way for you to, obviously, and reasons why you make gifts. So exclusion gifts, $17,000 per year for 2023 per donee. Gift splitting, so it's a married couple, it's 34,000. Gifts that don't qualify and don't count against federal state exemption amounts. So no need to file a gift tax return unless you're doing gift splitting. Must be a gift of a person of interest, of present interest, right? And must the present interest refers to gifts in which take effect immediately, and typically not gifts into a trust unless the trust has withdrawal rights. And gift tax exclusions for tuition and medical payments are actually out there as well. So the annual exclusion gifts, for example, right? Nate and Megan have two children. They give 68,000 times two. That 60 to $8,000 gift reduces their estate dollar for dollar. If Megan makes a gift and they can elect to deem the gifts as evenly split, Nate can consent to a federal tax return form 709 known as split gifts. So exemption gifts. Let's talk about, when you think about the exemption gifts, there's 12.92 in the lifetime of the exemption, right? And use that lifetime to make gifts above the annual exclusion, file a gift tax return, and then assets are subject to the carryover basis, right? But that allows some of those assets to grow outside of the estates. And with the gift tax, exclusion, there are a few disadvantages as well. So number one, the donor can retain any income or use or control the gifts properly. The donor basis for capital gains tax carries over to the donee. Gifts in excess of the exemption are subject to the gift taxes. So all important stuff there. Okay, let's talk about sources to pay the tax bill. Number one, sell the estate tax. Number two, liquidate non-liquid assets. Number three, borrow the money. And number four, use life insurance. Okay. So life insurance death benefit proceeds provide kind of a money situation, right? Liquidity in that situation. It's generally untaxed, untouched, and on time. Um, so trust can provide asset management, fiduciary responsibility, independent discretion, counting, paperwork, credit protection, spendthrift protections, and some tax advantages, right? So when you think about these, opportunities inside of irrevocable life and irrevocable trust and life insurance, it's a potential opportunity for you. So irrevocable life insurance trust and their characteristics, right? They're created during your time. They cannot be altered, amended, or revoked. Often funded by cash gifts to pay the premium on the insurance. Generally gives the beneficiaries the right to withdraw or to qualify for gifts, right? And it has some flexible terms built inside of it. Now, let's talk about the irrevocable life insurance trust in an example. Typical structures have many variations. The husband is the grantor, the wife is the income beneficiary. Income during the lifetime of the husband and death benefits are later. Income and principal distributions to the spouse. The children are allowable beneficiaries during the lifetime, and the trust owns a policy ensuring the life of the husband. The children are the remainder beneficiaries, and distributions are set at certain ages and hold for grandchildren as well, right? So basically, the gifts go inside of the trust for the annual exclusion or the exemption. Then the trust basically has beneficiaries and crummy powers, and then pays the premiums, right? So irrevocable life insurance trust, right? So the trustee is the applicant, the owner and the beneficiary of the life insurance contract. The policy is protected under the creditor and the creditors of the insured and the beneficiary. The insured gives cash to pay the premiums, and the gifts equal the annual tax exclusion for the beneficiaries and have crummy withdrawal powers and present interest to receive the gift. So the crummy powers, gifts into the irrevocable trust, um, are gifts of future interest. Gifts of future interest do not qualify for annual exclusion, and the trust documents must give the beneficial withdrawal powers to qualify for the gift tax annual exclusion. So a 30-day window to access the money when the gift is made. So all things that your wonderful attorneys will set up for you. There's a 3-year rule. So the decedent's gross estate will include the life insurance proceeds if the insured made a gift of the policy during the 3-year period prior to the date of the decedent's death. The trustee should be applicant and initial owner to avoid exposure to the 3-year rule. Um, so that's really important for the folks out there. Um, I've seen this a couple of times back in my days as a person doing the insurance. People would want a policy owned by a trust, but then they would go ahead and sign the paperwork themselves as the owner, and that kind of subjects you to the 3-year rule. So it's really important that you kind of build it that way if you're going to do this. So the summary here is pretty self-explanatory. I do want to kind of push off to a couple of things that are out there that we haven't covered, actually. So I think the ones that are out there are obviously the power of attorneys, medical power of attorneys, durable power of attorneys, all those things. Um, you know, when you look at folks, I think the most important thing that you have to consider is what's in your package. There's always the will or the trust, but then you have to have the power of attorneys, the financial power of attorneys, the durable power of attorneys, and then all the HIPAA documents that are built in there as well. So, typically what I tell people is they're considering different ways to do a will. There's several ways to go about it, right? The number one, obviously, is get an attorney. Number two is using an estate planning service. Number three is, potentially using some plan that you have at your employer. But if it's very complicated, very high level, I think you want to really consider using use your attorney, right? So I hope this helps you understand a little more about estate planning. What are all the different things that are out there? This is just kind of the tip of the iceberg and some general situations on estate planning. Let us know if you have any questions, concerns, and we'll be open for questions for the next few minutes. Thanks.